Hearing the appeal, Reyes against Malki.
Mr. Otti.
My lords, my lady, I appear with Mr. Luckhurst for Miss Reyes. Sir Daniel Bethlehem, Queen's Counsel, and Sudhanshu Swaroop, Queen's Counsel, appear for the respondents. Dr. Webb appears in principally an observer capacity for one of the interveners, Kalyan. Written submissions have also been filed by Kalyan and by the Secretary of State for Foreign and Commonwealth Affairs. And the court will have received quite a volume of written material, I'm afraid including material that's arrived since the bound volumes. And I wondered if I could just check that all of that had been safely received. The materials that came after the bound volumes comprise our submissions dated the 3rd of May, responding to the respondents and the Secretary of State's case on the cross appeal. A letter from Kalyan dated the 9th of May, enclosing extracts from a recent decision of the Inter-American Court of Human Rights. Further authorities submitted by the respondents on the 11th of May, which I think should have come in a slim bound volume. And then finally, a letter from the Secretary of State on the 11th of May, dealing with one point of practice on the question of service relevant to the cross appeal, and also containing some brief observations on the Inter-American Court decision.
I'm not sure that I do have those documents.
Well, we will...
Could be in the Pleistocene layer of my papers in my room.
We will put together...
The last of those that you've referred to, I certainly don't have.
The Secretary of State's letter.
Yes.
We will certainly arrange for a copy of that. It relates, as I say, principally to the cross appeal, and so needn't detain us for present purposes.
Okay. Well, I've got 2 copies of it, so you have one. Yeah.
You're very kind.
Okay. Well, when we come to a document, you better be ready for somebody or more than one person to say they haven't got it, so we have a spare copy.
Best.
Thank you.
My lord. The only additional document that I wanted to draw to the court's attention is one we have placed on the court's desk this morning, which is a very short note from us setting out the key stages to our case and what we respectfully submit to be the principal flaws in the respondent's case.
There's a thing called case summary.
Case summary, that's it, my lord. And alongside that, we've also handed in a one-page document seeking to set out the various treaties to which both the United Kingdom and Saudi Arabia, or one or other of those states, is a party with relevance to this context. My lords, my lady, the appeal, as you have seen, raises 2 questions. Firstly, whether the present proceedings should be characterised as relating to a commercial activity exercised by the first respondent within the meaning of Schedule 1 to the Diplomatic Privileges Act and Article 31(1)(c) of the Vienna Convention on Diplomatic Relations. And secondly, whether, if they should be so characterised, the commercial activity in question should be characterised as having been exercised outside the first respondent's official functions. Now, in addition, the respondent's cross-appeal raises a third question as to the validity of service of these proceedings on them. We, of course, contend that the answer to both questions raised on the appeal should be answered yes, and that the cross-appeal should be dismissed. Now, underpinning each of our submissions is what we contend to be the relevant context of this appeal, that my client was the victim of conduct on the part of the respondents, which meets the international definition of human trafficking. And her case involves the 4 key stages we've set out on page 1 of the case summary document I mentioned a moment ago. The first is that human trafficking is itself properly to be characterised as a commercial activity. It is described by the United Kingdom government repeatedly as a form of modern slavery. it yields a specific and intended financial benefit to its perpetrators, and its perpetrators include all those involved in the trafficking chain, beginning with those who recruit, embracing those who transport, and extending to those who receive. The second stage is that the present proceedings must be held to relate to trafficking by the respondents, in circumstances where, as the Court of Appeal found, 10 indicators of trafficking were formally pleaded against them, and where the government has itself identified employment proceedings as one of the key means by which victims of trafficking may seek redress. The third stage is, we say, that it naturally and logically follows that employment tribunal proceedings such as those brought by my client should be held to be an action relating to commercial activity. And we say that conclusion follows whether one applies the Vienna Convention on the Law of Treaties, common law principles of statutory interpretation, or principles of interpretation flowing from the Human Rights Act or the European Communities Act. And the fourth stage is that engagement in human trafficking must inevitably, we say, be held to be outside a diplomat's official functions, as should employment of an individual for purely personal purposes. Now, the Court of Appeal appeared to accept the first of those four stages, namely the inherently commercial nature of trafficking, and it expressly accepted the second, namely that these proceedings related to trafficking, but it rejected the third and the fourth. Now, before addressing each of those stages in more detail in turn, I'd like to emphasize, if I may, by way of introduction, what we submit to be the 7 principal flaws in the respondent's case in response, and which we've set out in the note, and each of which I'll seek to pick up in more detail as I develop the 4 stages of our argument. So again, this is on the 2nd and 3rd page of our case summary document. The first point is that this case is not concerned with the displacement of an established immunity. And so the respondent's citation of cases such as Jones or Kazemi from the Canadian Supreme Court, we respectfully say, simply miss the point. The appeal is concerned instead with the correct interpretation of an established but undefined exception, provided for in domestic legislation and international law. The second flaw, we say, is that resolution of this case in Ms. Reyes' favour would not leave the United Kingdom in breach of its international law obligations to the Kingdom of Saudi Arabia. It would in fact yield, we say, an outcome which would be entirely in harmony with Saudi Arabia's own commitments in this area. The third point, the third flaw, we say, is that the respondents are wrong to criticise the decision of this court in Haunger and Allen. We say that decision was correct to support a non-technical approach to the classification of claims related to trafficking, and that the Court of Appeal was correct to apply that approach in this case. The fourth flaw is that diplomatic immunity cannot, we say, be entirely severed from the law of state immunity and consular immunity in the way that the respondents seek to achieve in order to marginalise the reliance we place on the state immunity cases. The fifth flaw is that the respondents fail, we say, properly to acknowledge the mandatory nature of the interpretive obligation imposed by Section 3 of the Human Rights Act. There are repeated references, as you have seen, to Fothergill and the proposition that where one is construing legislation which incorporates an international instrument, domestic principles of interpretation should be set to one side. Well, whatever the strength of that proposition in this case, so far as some rules of interpretation are concerned, it cannot oust the mandatory obligation imposed by Section 3 of the Human Rights Act. The sixth point, going to the second question on the appeal, the respondent's approach to the concept of official functions is inconsistent with all previous authority in this jurisdiction and elsewhere, including authority from the United States of America, the jurisdiction upon which the respondents place the greatest reliance. And the seventh and final point, which is essentially the policy argument which underpins a great deal of the respondents' submissions, the respondents are wrong to assert, we say, that were Ms. Reyes' appeal to be allowed, it would cause some unacceptable impairment to the discharge of diplomatic functions. That cannot be so, we say, for the three reasons we've set out in that last paragraph on page 2. Firstly, we know from Article 31(1), whatever it means by way of precision, that all signatories to the Vienna Convention were prepared to contemplate some form of assertion of civil jurisdiction over diplomats. Secondly, the term commercial activity is undefined, and so it necessarily falls, and must have been anticipated to fall, to municipal courts to define it. And thirdly, there is good reason to believe that the drafters of the Vienna Convention would have considered involvement in the slave trade or its modern-day analogue to be prohibited commercial activity. And the reason for that, and we'll come on to the extent to which recourse can properly be made to the Travo, the reason for that is that one theme that runs through the Travo quite clearly is that Article 31(1)(c) is intended to capture conduct which would infringe or breach the dignity of the mission. There can be no doubt whatever that involvement in trafficking would meet that criterion. And we say there could be no doubt whatever, viewed sensibly, that had the drafters in 1961 been asked, when you refer to commercial activity, would that embrace involvement by a diplomat in the slave trade? The answer of everyone would have been yes, of course. And if that's right, then in circumstances where today, viewed through the modern lens of interpretation that should apply, modern-day slavery should yield the same result. So, my lords, my lady, that is a brief overview of the stages of our argument and what we respectfully submit to be the flaws in the respondent's case and obviously, to some extent also, the flaws in the Court of Appeal approach. Although, as I say, on 2 of our 4 stages, we think we had the Court of Appeal with us. The first of those stages is then the commercial nature of trafficking. It wasn't seriously challenged by the respondents below and doesn't appear to be in the printed case. It also appears to have been accepted by the Court of Appeal. Now, we've addressed it in paragraphs 7 through to 13 of our printed case, with 2 of the material passages from the Court of Appeal judgment set out at paragraphs 12 and 13 of that case, where the sheer scale of the slavery and trafficking industry is addressed. It's described in some of the materials as the 2nd or 3rd most profitable of global illicit trades, the first being drugs and the second one being arms. The definition of trafficking is then addressed at paragraphs 7 to 11 specifically of our case, and there are 6 points that I'd like to emphasize from those passages. First, and this is in paragraph 7, a point I've already made, the definition extends right across the trafficking chain, from recruitment right through to receipt. Secondly, this is paragraph 7 and 8. Exploitation, one of the key elements in the definition of trafficking, includes forced labour or servitude. And as the Home Office guidance has explained, domestic servitude often involves work under conditions, we say, which apply directly in this case. Work under conditions of humiliation, work for exhausting hours for little or no pay. Thirdly, and this is again apparent from the definition itself at paragraph 7, consent in any form on the part of the victim is irrelevant where one of the prohibited means is used. The prohibited means being coercion, deception, abuse of power or position of vulnerability, so far as this case is concerned.
Do you say that this case would fall to be decided differently in the event that the particular claims made by the claimant, unlawful deduction from wages, race discrimination, breach of the working time regulations, let us suppose that those same claims and allegations were made but without the element of trafficking? Is it your submission that if the background to these particular breaches of duty is trafficking, the result falls to be decided differently, although the claims are exactly the same?
My primary case, my Lord, is based solely on trafficking, and a finding in my favour on the basis of trafficking would not inevitably lead to the conclusion that all employment claims involving those allegations would meet the definition of commercial activity.
So the present case would fall to be treated differently if the identical claims for the identical breaches were made but without the background in trafficking?
On my primary case, my Lord, yes, trafficking is an integral part of it.
But you wouldn't mind
I wouldn't mind if you went further.
if this court went further and said that purely private domestic employment was a commercial activity outside official functions for the purposes of the Act and the Convention.
Exactly.
You wouldn't mind that at all, but you think you've got a stronger case if you focus on the commercial aspects of trafficking.
That's exactly how we put it, my lady. And I'll go through the cases from the state immunity context which deal with employment relationships meeting the definition of commercial activity. I'll go through even those cases against me, such as Tabian from the United States of America, which acknowledge that the literal meaning of commercial activity within this convention is sufficiently broad to embrace employment relationships. And I'll go through cases from Canada and Portugal, which have interpreted given a sufficiently broad interpretation to 31(1)(c) to allow all employment claims of that character to be within 31(1)(c). Against me, I've essentially got the United States line of authorities and some academic commentaries. Our point, and that's the way we put our primary case, is that this case actually can be decided very simply in my client's favour through the 4 stages I've identified, with trafficking obviously being an inherent and important step in those stages. But if it were necessary for me to go further, then I do go further, and I hope we've said it sufficiently clearly in our printed case, that we would invite this court to prefer the views articulated in the context of the state immunity cases, to prefer the views articulated by the Canadian and Portuguese courts to those articulated by the United States courts. In some ways, my Lord, the debate perhaps becomes starker on this issue when one gets into the question of what use does one make of the travaux and how does one deal with the interrelationship between Article 31(1)(c) and Article 42, which I'll come on to.
Well, there's also the interrelationship within Article 31(1)(c) between the requirement that between the words commercial transaction and the words, I'm paraphrasing, not in accordance with official functions.
My lord, yes.
The result might be different depending on whether those are two disjunctive requirements or whether one is explanatory of the other. I think your submission is that one may be explanatory of the other, so that in effect, in diplomatic immunity, as in state immunity, everything which is not done for the purposes of a sovereign act is a commercial activity, notwithstanding the slightly inappropriate use of commercial.
My lord, yes, and that certainly seems to be the approach, for example, that the Portuguese Supreme Court took. So I was going through the key points from paragraph 7 to 13 on this first stage, though, the commercial nature of trafficking. And the point I was making there, which led to this series of exchanges, was based upon the definition of trafficking at paragraph 7, and the emphasis there on the fact that consent on the part of a victim is irrelevant if one of the prohibited means has been used. The fourth point, and this is in a sense one which goes to the broader harmonious interpretation argument, which I've already flagged and will develop in more detail in due course. This definition is present in both the UN protocol, Palermo Protocol, to which both the United Kingdom and Saudi Arabia are parties, and in the Council of Europe's Anti-Trafficking Convention, to which all members of the Council of Europe, apart from Russia, are parties. The fifth point, this is from paragraphs 9 and footnote 5, the court found in Hunga that it was legitimate to have regard to the International Labour Organization's indicators of forced labour in determining whether an individual is properly alleged to be a victim of trafficking. And those indicators include issues such as deception, withholding of identity documents and wages, and abusive working and living conditions, all present on the way we put our case. Sixthly, and this is paragraphs 11 and 12, the gravity of the conduct is, the appellant submits, aptly captured by the description of it that I've already alluded to by the government as modern slavery. And that characterization was one which the Court of Appeal at paragraph 38 accepted was widely recognized. Now, it's important to emphasize at this point that that characterization and the high status of the prohibition against trafficking which it reflects is relevant not because we seek to displace an established immunity by reference to a superior rule of law. It is relevant, we say, because involvement in the slave trade should readily fall within the definition of commercial activity and would have done so in 1961. And it follows, we say, that its modern incarnation should do likewise. And it's relevant because, as I've already submitted, one of the touchstones identified in the Travo for activity caught by the commercial activity exception is whether it would justify a declaration that a diplomat was persona non grata.
Are all forms of trafficking commercial? I mean, is there a difference, at least arguably, between those who do the transporting and effectively selling of people and those who receive the benefit because they then employ those people? I mean, is it necessarily the case that every aspect of participation in the trafficking process, the chain from beginning to end, is commercial? Some quite obviously are. Is there room for doubt as to whether the others necessarily are?
We say no, my lord, for two reasons. Firstly, the definition itself expressly extends to everyone in the chain and treats everyone in the chain as involved in the same international
It's
role.
them all as involved in trafficking, but it doesn't treat them all as commercial, which is a label that you have to attach to it for the rather special purpose with which we're concerned.
Well, the second reason, my lord, is that everyone involved in the trafficking chain and caught through that definition as involved in trafficking is yielding a financial gain of some kind. Now, it may be more obvious, as my lord says, to characterise the driver of the lorry who receives a fee for the transport, or the initial recruiting agent who receives a fee for the recruitment, than the ultimate recipient. But the ultimate recipient is, we say, yielding, through their involvement in trafficking, a clear and direct financial gain. And that is entirely sufficient to bring matters within the definition of trafficking. Now, perhaps an illustration of the reason there shouldn't be any sort of bright line distinction of the kind my lord has contemplated is provided by the facts of the two cases before the court on this appeal, albeit that Miss Reyes is the only active appellant. Miss Suriadi's facts are referred to, and as you've seen from the way we summarise those in our printed case, Miss Suriadi's factual allegations included assertions that she was told by her employer, the second respondent on this appeal, that she had been bought. The ultimate vice, my lord, we say, which is reflected in the prohibition on slavery in its original definition in 1926, and the prohibition on trafficking today reflected amongst other places the Palermo Protocol, is, to use the words of the European Court in the relatively recent Ransef case, that people are being treated as objects or commodities. And once one gets into that territory, we say there is no room for the bright line distinction, although I well understand my lord's point that it may be blindingly obvious in some cases, but we say it's correct that it embraces all of those involved in the chain for the reasons I've submitted. And if if one of the guiding tests is the approach that I've mentioned from the Travo, namely engagement in conduct which essentially brings into disrepute and lowers the dignity of the mission, then it's hard to see why engagement at one stage of the trafficking chain should have that effect, but engagement at another stage wouldn't.
But you're presumably limiting this to knowing participation,
Yes.
not to a sort of innocent recipient of this person who has been trafficked.
And in our case, the deception that we rely upon as the prohibited means is a deception that we allege against the respondents. They're involved on day one, in this case, through the deceit as to the paying conditions that will apply upon transfer to this jurisdiction and work here.
Is the existence of a financial benefit a sufficient basis on which to describe it as commercial? Is that what you're submitting?
It is, my lord, yes, and it's supported further once one looks at the industry as it's described of trafficking more broadly. Certainly, if one takes the prop end approach and one takes a very narrow view, and we would say perhaps an overly narrow view, to how Article 42 feeds into Article 31(1)(c, the requirement that Article 42 is said to import is a requirement for activity which yields a personal profit.
So would the fact of paying less than the national minimum wage ipso facto constitute commercial activity?
On the secondary and not necessary way I put my case, it would, my lord. On the primary way I put my case, namely this is a case about trafficking and that can't be simply shunted to one side, I don't need to submit that, because if you had, for example, a situation involving no deception, actual as well as theoretical consent, and engagement of an individual for reward in this jurisdiction to perform services, which might, for example, yield for that individual a better rate of pay than they would receive in another state, then it would be very difficult to say that that kind of conduct met the epithet captured in the Travo of bringing the dignity of the mission into disrepute. And so I don't need to go that far, but if necessary, I do, my lord. So those are the key points, my lords, my lady, we draw from the definition of trafficking. The commercial nature of trafficking broadly speaks largely for itself. We've addressed some of the statistics at paragraphs 12 and 13 of our printed case. We've pointed out at paragraph 12, as I say, that the Court of Appeal accepted that trafficking was widely regarded as a contemporary form of slavery. Calian's submissions on this appeal, as they did before the Court of Appeal, also support the characterization of trafficking as commercial in nature. And it's entirely clear from the materials that they have put before the court that the Court of Appeal was absolutely right to say that the characterization of trafficking as modern slavery is widely supported. It's supported by the United Nations, it's supported by the OSCE, and it's supported by governments across the world, including the United States, Canada, and Australia. I won't go to them, but I'll just give the references if I may. Calian's submissions on this are at MS 246. 246.
246.
And the particular paragraphs on this are 11 to 13, 23 to 29, and 49 to 55. Now, against that background, we say it is obvious that if a diplomat engaged, for example, in the transport for reward of a trafficked person as part of their trafficking, that would be commercial activity falling outside his official functions. And if that is so, and this is really to repeat the answer I've just sought to give to my Lord Sumption, if that is so, then given the definition of trafficking, the recruitment or the receipt of persons for the purposes of such exploitation should also do so. I'll give the court, if I may, the references to the factual allegations made by Miss Suriadi by way of the broader context to this appeal. They're at Core Volume 2, MS 794, and at paragraphs 8, 13 and 25 of her witness statement.
Might be better to concentrate on Ms. Reyes, and I think the reference for that is 681, Mr. Rodney.
Yes, I'll go to her
Very well.
position in a moment. That is then the first stage of our argument, that trafficking in all its aspects is a commercial activity. The second stage of the argument, which is one where the Court of Appeal was expressly with us and which the respondents challenge, is that this appellant, Ms. Reyes' claims, relate to trafficking. And we've set out the factual background to her case at paragraphs 14 to 20 of our printed case. Mm-hmm. The Court of Appeal's approach to this issue at paragraphs particularly, well, from paragraph 21 on, but particularly paragraphs 22 and 23. And as we say at paragraph 22 of our printed case, the Court of Appeal accepted that the 10 indicators of trafficking which had been identified by the relevant United Kingdom body, the United Kingdom Visas and Immigration Division of the Home Office, in Miss Reyes's case, and which had led first to a decision that there were reasonable grounds to characterise her as a victim of trafficking, were each pleaded in her case in these proceedings. Now, at paragraph 22 of our printed case, we've set out there with the footnote references the specific key indicators featuring in the pleading. They included deception, they included non-payment, they included excessive working hours, they included severe restrictions on freedom of movement, they included prohibition on contact with others, lack of private space, retention of travel documents, and a situation of dependency. Now, against that background, as we say at paragraph 23 of our printed case, the Court of Appeal accepted that it would be overly technical to contend that since the formal causes of action relied upon by Ms. Reyes lay in the field of employment law, her claims did not relate to trafficking. Now, the respondents, as I say, challenged that finding. We say, with respect, that they're wrong to do so for the 4 reasons that we've then sought to set out at paragraph 25 of our printed case. The court was following a similar approach to that taken by this court in Hunga, which I'll come to in more detail in a moment. The Court of Appeal's approach was entirely consistent with the repeated approach taken by the government itself in characterising employment proceedings as one of the key means by which victims of trafficking were able to seek redress. The respondents themselves had previously asked the Employment Tribunal to proceed on the basis that the allegations made were true, so we say, rather undermining their complaint that the proceedings before this court, in contrast to those considered in Hunga, had yet to arrive at any firm factual findings. And fourthly, notwithstanding the respondent's contention to the contrary, Ms. Reyes clearly had a properly arguable case, to put it no higher than that she was the victim of trafficking at the hands of the respondents, for each of the reasons we've set out at 25.4. Now, I'll go briefly to Hunga now, if I may. I know my Lord Wilson and my Lady Baroness Hale will be very familiar with it. But before doing that, it's perhaps notable to emphasise that on this issue, notwithstanding their intervention on other issues, the Counsel for the Secretary of State does not challenge the approach of the Court of Appeal. And so it appears to be common ground, at least between the appellant and the Secretary of State, that the Court of Appeal was right to characterise Ms. Reyes's claim as one relating to trafficking. Now, Hunga is at tab 9 of bundle 1, MS 1270.
I think even those 3 of us who were not in it have had cause to look at it fairly recently.
I'm very grateful for that, my Lord. In that case, I'll take it quite quickly, if I may.
Yes, that was the intention of me telling you. Yeah. Thank you.
As the court will recall, the claim was brought by a young woman who'd come to the United Kingdom as a child to provide domestic work for the respondent on the back of promises of pay and schooling and through false documentation. The promises were breached and serious physical abuse and threats followed, culminating in the claimant's eviction from the respondent's home. That then led to a claim before the Employment Tribunal, alleging, amongst other matters, unlawful discrimination in the circumstances surrounding the employment. The claimant was successful before the Employment Tribunal and the Employment Appeal Tribunal in relation to her claim for discrimination, but the Court of Appeal had allowed the employer's appeal on the basis that the original contract of employment was illegal, and to permit the claim would be to condone the illegality. Both the Employment Tribunal and the EAT had rejected claims for unfair dismissal, breach of contract, unpaid wages, and holiday pay by reference to that principle, the principle of illegality. And those findings had not been appealed to the Court of Appeal, so were not before this court when it came to consider the case. Now, as you'll recall, the court unanimously allowed the appeal in relation to the claim that was before it, and at paragraph 24 in my Lord Wilson's speech, appeared to at least contemplate that the other claims might also have been permitted to go forward had they been live issues before the court. All 5 justices held that the illegality on the claimant's part was not so closely connected to the claimant's claim as to give rise to the defence of illegality. And the majority, 3 of the 5 members of the court, also held that to uphold the defence of illegality would place the United Kingdom in breach of its obligations under Article 15.3 of the Council of Europe's Anti-Trafficking Convention. They held that even though her formal cause of action was for the statutory tort of discrimination, that claim was related to her status as a victim of trafficking, and its availability represented a means by which the United Kingdom could discharge its obligation to provide for a right of victims of trafficking to compensation. My Lord Wilson's speech is the leading speech for the majority, and the material passages for present purposes begin at paragraph 42, I think.
Thank you.
And your Lordship there identified 2 questions as being material to the application of the illegality defence. What was the aspect of public policy which founded the defence, and was there another aspect of public policy to which application of the defence would counter? And then at paragraph 46, your Lordship held that consideration of that second question required the court to consider whether the respondent has been guilty of trafficking the claimant. At 47, the international definition of trafficking, which we've just looked at, is then set out. At 49, your Lordship referred to 4 of what were then the 6 International Labour Organization indicators of forced labour, and concluded that it was difficult to resist the conclusion that the claimant was a victim. By way of footnote, those indicators have since been updated. The current 11 published indicators are set out in our printed case at paragraph 9 and appear in the authorities bundle at MS 5079. Now, in Miss Reyes' case, even using the indicators as set out in Haunger, at least 3 of the 6 indicators would be made out: restriction of movement, passport retention, and withholding of wages. If one uses the 11 current indicators, 8 of the current indicators would be made out. We then see at paragraph 50 of your Lordship's speech the reference to Article 15.3 of the Anti-Trafficking Convention, and the holding that first it was too technical an approach to say that the article related only to trafficking per se, and so not to related acts of discrimination, and secondly, that to cause the claimant's claim to fail by virtue of the principle of illegality would be to place the United Kingdom in breach of its own international law obligations, something which ran counter to the common law presumption identified by Lord Hoffman in Lyons. At 51, we have the Ransef case I've referred to, already cited, with paragraph 282. As I say, and I'll show the court in due course, paragraph 281, with the characterization of trafficking as involving assertions of rights attached to ownership, is also important. Paragraph 52 of your Lordship's judgment or speech is also important to a later stage of the argument, because it's there that your Lordship is acknowledging that Article 4 of the Human Rights Convention carries with it positive obligations to combat trafficking and protect victims. It's apparent from the sentence beginning, no doubt, by letter G. And then by letter H, having cited other developments in the area, your Lordship concludes that to uphold the defence of illegality would run strikingly counter to what was described as the prominent strain of public policy against trafficking. Now, Lord Hughes, with whom Lord Carnworth agreed in the result, but did not agree with the reasoning relating to Article 15.3. Lord Hughes's consideration of human trafficking begins at paragraph 60, and I think the material passage that's relied upon by my learned friends is that at paragraph 65, where Lord Hughes expressed the view, by reference to the Palermo Protocol rather than to the Anti-Trafficking Convention, that the statutory tort of discrimination was not coextensive with trafficking or exploitation, and that on that basis it would not be possible to interpret the Palermo Protocol as requiring English law to depart from general principles of illegality. Now, the respondents say that the approach taken in Haunger should not be followed for three reasons. They say, firstly, it didn't involve an issue of immunity, and so it's distinguishable. Secondly, they say there's no basis in these proceedings to regard Miss Reyes as a victim of trafficking, or the respondents as perpetrators, because there haven't yet been any findings of fact, and they say the Court of Appeal hasn't given any adequate reasons for its approach. And thirdly, they say that the approach of the minority in Haunger, as they summarise it, should be preferred. None of those arguments, we say, should be accepted. As to the first, the suggested distinction by reference to the concept of immunity, the fact that Haunger was not concerned with immunity is irrelevant to this stage of the argument. At this stage of the argument, the case is being relied upon by our side for the simple purpose of determining whether proceedings are related to trafficking, even if the formal cause of action in play is not so described. And on the authority of the majority, we say that must follow. As to the second point, the absence of findings of fact, we say that presents no obstacle to Miss Reyes' case either, and the criticism of the Court of Appeal is misplaced for three reasons. Firstly, as I've already mentioned, the respondents themselves had argued that the Employment Tribunal should proceed on the basis that the facts alleged in the claimant's pleadings were true. That's our printed case 25.3. Secondly, the question under the Diplomatic Privileges Act is necessarily concerned primarily with allegations of commercial activity rather than findings of commercial activity. Otherwise, it would be open to a diplomat to entirely avoid the exception merely by a bare denial that any activity at all had been engaged in. And that's a point we make in our printed case later on at paragraph 65. And thirdly, the suggestion that the Court of Appeal gave no adequate reasoning for its conclusion that these proceedings were related to trafficking is, we respectfully submit, odd. The Court of Appeal held in terms that 10 indicators of trafficking had been pleaded, paragraph 31 of its judgment. The Court of Appeal had referred to the United Kingdom Visa and Immigration Office's conclusion that the claimant was a victim of trafficking, again paragraph 31. And in its earlier reasonable grounds decision, that same competent authority, the UKVI, had expressly stated that in reaching its reasonable grounds determination, it was applying the anti-trafficking definition which featured in Haunger. And the reference in the papers to that is MS 777. Sorry, MS 760 and MS 77 for the reasonable grounds and the conclusive grounds determinations. So it follows, we say, inexorably from Haunger, as the Court of Appeal essentially accepted, that we're also right on stage 2 of our argument. Trafficking is commercial, and these proceedings relate to trafficking. And that takes me to stage 3. And we say it follows logically and very simply from stages 1 and 2 that these proceedings do relate to commercial activity on the part of a diplomat. Now, that conclusion is only further supported, we say, if one then has regard to the 4 potential sources of interpretative guidance available: the Vienna Convention on the Law of Treaties, the Common Law, the Human Rights Act, and the European Communities Act. But we say, in essence, that before we even get to those 4 sources, as a matter of ordinary interpretation and simple application of those first 2 stages of the argument, that we're at least 40 love up. The Vienna Convention on the Law of Treaties first. This is at Bundle A1, Tab 5.
Yes.
Bundle A5, Tab 53, MS 2308. And we've addressed it in our printed case at paragraphs 66 through to 76. And it's also addressed by the Court of Appeal in Court of Appeal's judgment of paragraphs 9 through to 25. Now, you'll note, of course, that the
authorities bundle what? Tab 53.
Tab 53 should be the Vienna
Beginning of
Convention.
bundle 5. Yeah.
Now, it's, of course, a treaty which post-dated the diplomatic convention, but it was recognised in Fothergill and other places that it essentially reflected customary international law, and so that sequencing is of no relevance. The material provisions of the treaty are Articles 31 and 32, governing questions of interpretation. The primary rule is that set out at Article 31.1, as we said in 66 of our printed case, and it requires consideration of the ordinary meaning of the words used in their context and in the light of the treaty's object and purpose. And the context is then defined at 31.2 as comprising the text, including its preamble and other related instruments. Article 31.3 then enshrines, we say, the principle of harmonious interpretation by permitting reference to other relevant rules of international law applicable between the parties. And Article 32 permits a supplementary means of interpretation by reference to the travaux préparatoires if the meaning of a term is ambiguous or obscure after the Article 31 exercise has been performed, or if the Article 31 exercise yields a manifestly absurd or unreasonable result. So, ordinary meaning first. As I've just sought to indicate, the first point Ms. Reyes makes is a very simple one. If she is correct that trafficking is commercial activity, and if she's correct that her proceedings relate to trafficking, then that is the end of the matter. Even without the trafficking context, however, so far as ordinary meaning is concerned, she's also able to rely upon 3 further points as showing her proceedings would be within the wording. And this perhaps takes me back to the first question my Lord Sumption asked this morning. And the 3 points she relies upon are these. Firstly, the respondents have conceded in terms that the words commercial activity are capable of including entry into an employment contract. That's their printed case at paragraph 69. Secondly, such comparative case law as there is relating specifically to diplomatic immunity, including that cited and relied upon by the respondents, has also accepted that the literal meaning of the words commercial activity could embrace an employment contract. So in that context, we have case law from the United States, Canada, and Portugal. And the third point is that literal meaning is further supported, we say, by case law relating to state immunity from 2 other leading common law jurisdictions, Canada and the United States. Now, the first of those points, the concession, speaks for itself, although it's notable that the Court of Appeal did not refer to it in its judgment, although very fairly Sir Daniel had made the same concession before the Court of Appeal. I'd like to say a little more about the second and the third, the diplomatic immunity case law and the state immunity case law. Diplomatic immunity case law first. This is addressed in our printed case at paragraphs 45 to 47, 51 to 53, and 61. And as I say, these also treat the literal or logical meaning of the words commercial activity broadly, and so as capable of extending to employment contracts, regardless of the trafficking dimension. Now, the first case in time is a 1989 decision from Canada called Singhal and Babasale, which is in Authorities 11, tab 113 at MS 4380. This was not an employment case, but it related to other in personam claims brought, again, in fact, against a Saudi diplomat, this time for breach of a lease over what appears to have been the diplomat's domestic residence. And the court's conclusions on Article 31(1)(c) are set out at pages 3 and 4 of the judgment. Beginning towards the foot of page 3 with the paragraph turning then to the third subsection and running over the page to the end of the main paragraph on page 4. And you see from those passages that the judge had regard to the ordinary meaning of commercial activity as derived from Black's Law Dictionary by virtue of the payment of substantial sums of money and the assumption of a range of rights and obligations. It's true that he distinguished in his observations between state immunity and diplomatic immunity, but he also then essentially applied the same meaning to the same words where they were used in those 2 different contexts. Now, so far as we're aware, the heavens haven't fallen in diplomatic relations between Canada and Saudi Arabia in consequence of that decision.
Yeah.
Moving then from North America to Europe, the next case in time, which considers the meaning of the commercial activity exception, is the 1991 decision of the Supreme Court of Portugal in Fonseca, which we've addressed at paragraphs 45 to 47 and 61 of our printed case, and that's in Bundle 2, tab 17, MS 1668. And this case concerned an employment contract between a domestic servant and the first secretary of the French embassy. And you see...
What page did you say?
Page 1668, my lord, is the translation of the ruling.
Thank you. Yes, I see. Thank you.
And it's absolutely right to say, and is obvious, that the reasoning in this case is very brief. But it is also apparent, we say, from a series of passages on page 1669 of the bundle, that the fundamental approach being taken by the court was to treat diplomatic immunity as closely linked to state immunity. And the fundamental approach was to draw a divide between official acts, sovereign acts, and non-sovereign acts, or non-official acts. And we get that from a series of passages on page 1669.
Yep.
About 12 lines down, the Vienna Convention came to regulate the immunity from jurisdiction of a sovereign state in relation to another state.
Yep.
The next sentence, more recently, the distinction came to be made between absolute immunity and relative immunity. Further down, just at halfway down the page, in the preamble to the convention, there is the declaration that the purposes of these privileges and immunities is not to benefit individuals, but to guarantee the effective performance of the functions of diplomatic missions. The next sentence, what is intended with the granting of immunity is to guarantee the reciprocal independence of states, avoiding the situation of making a state a defendant in the courts of another state. And then the last main section, the Vienna Convention itself gives this result. The reference to Article 31, and then finally, it was intended to exclude all activities outside the diplomat's diplomatic functions. And amongst these is the contracting of a domestic maid to perform services in the diplomat's private residence.
Well, that was a proposition which the Court of Appeal doesn't seem to have accepted.
It doesn't, and it found that the reasoning in Fonseca was too brief to be of assistance. The reason why we say that the Court of Appeal was wrong to essentially set entirely to one side the approach that's taken in state immunity is that an earlier recital, as we'll come to it in a moment, an earlier recital in the Vienna Convention on Diplomatic Relations expressly acknowledges the issue of sovereign equality, which is at the foundation and at the core of state immunity. And the principal domestic authority relied upon against me before the Court of Appeal, the case of Propend, also treated diplomatic immunity as one branch of state immunity. And so we say, in terms of the substance, the approach taken by the Supreme Court in Portugal was right and consistent with earlier English case law.
It's right. Is it right that the diplomatic immunity of an individual diplomatic agent can be waived only by the head of mission?
Yes, it can only be waived by the state.
This somewhat reinforces your submission that this is an aspect of the privileges of the state rather than the individual.
Exactly so, my lord, as indeed does the other the recital that's relied upon quite heavily against me, to the effect that the Vienna Convention is not intended to benefit individuals, but is intended to promote diplomatic function. Now that, we say, is another indicator that this is really all about the state's interests. And yes, absolutely, we rely upon the fact that waiver can only emanate from the state. We also say, and we'll go through, of course, the Vienna Convention itself in more detail in a moment, looking at context and purpose, but we also say that there is a grave risk of overstating the impact of a finding such as that pursued by Ms. Reyes on the discharge of diplomatic functions. Because there will still remain, even if we're right on everything we say, substantial immunities in place for a diplomat.
Oh, there's got to be some concept of remoteness involved here. I mean, if the activity in question does not itself constitute the performance of diplomatic functions, how far does one go away from that activity before the immunity ceases to apply? If the diplomat has a holiday cottage in the country, is it enough to say that the performance of his diplomatic functions are eased by the rest and recreation that he will enjoy during his holidays?
And yes, my lord, when we say not, and that's maybe, I don't know whether it was a holiday cottage or a primary residence, but the approach taken in the Canadian case was along those lines. And we also see when we get to the official functions stage of the debate, we see that Mr. Justice Langstaff, sitting in the EAT in these proceedings, had identified a spectrum across which one could consider this specific activity to really determine as a matter of common sense whether it was within or outside official functions. Now, all of those passages and the authorities that Mr. Justice Langstaff identified are simply ignored by the Court of Appeal with respect when we get to that stage of the debate.
What was the Court of Appeal's reason for saying that the employment of domestic staff was connected to the diplomatic functions of the honour?
It was said to be, there are a number of references. At one point, there's a suggestion that Ms. Reyes, that there was employment at the mission, which was factually inaccurate. But more substantially, the Court of Appeal asserts, and we respectfully submit does no more than assert, that the engagement of a personal servant is conducive to the discharge of diplomatic functions. And the most substantive point that's relied upon is that the Vienna Convention contemplates that diplomats will engage personal servants. Because, for example, in Article 10 of the Vienna Convention, there is reference to procedures which apply to the entry into this country of personal servants. I'll come on to all of that in more detail, but it doesn't, we say, provide anything like an adequate foundation for the conclusion that engagement of a purely personal servant in your home for purely personal purposes is within official functions. Now,
Sorry, Article 10.
Article 10, my lord, yeah. I mean the Vienna Convention on Diplomatic Relations.
Yes.
All right. Or that's the reference, rather.
Yes.
Is there a specific provision of the State Immunity Act relating to employment?
Yes, there's a provision relating to both commercial transactions and a separate one relating to employment.
Has that been copied? I don't think it has.
It's in the supplementary bundle that my learned friends put in last week.
Yep.
And those provisions are the subject of the related case, which is to be heard by this court in 2 weeks' time, of Benkabush.
Which section of the State Immunity Act?
It's Section 5, I think it is, my lord, that deals with employment.
Sorry,
Sorry,
Section 5? No.
Section 4 it is. Section 5 is personal injury. Section 4 is contracts of employment.
Thank you.
I mean, it would seem on the face of it a little odd if a state was not immune in respect of a contract with a waiter employed in the mission itself, whereas a diplomatic agent was immune in respect of a waiter that he employed at his private dinner parties.
My Lord, yes.
I don't know whether that would follow from the...
There are extra twists to Section 4 which require some teasing out, and which will be... I can take the court to Ben Caboose in the Court of Appeal in due course if I may, but it is odd, we would respectfully submit, and supports our case. It's right to say, my Lord, that there are circumstances in which a diplomat will enjoy a greater level of immunity than a state. So to give one example, if a diplomat engaged in what was on any view commercial activity, doing so expressly within his official functions, then he would be immune, a reference to Article 31(1)(c), on one reading of that provision, but the state would not.
Well, that would depend on whether the activity in question was an exercise of sovereign authority. Trade promotion or tourism promotion must give rise to a lot of borderline cases.
My Lord, yes. But the purchase of aeroplanes, for example, might be different if the diplomat was engaged. Likewise, state immunity, a state does not have immunity from damage to property claims, where the damage to property occurs in the jurisdiction, Section 5 of the State Immunity. But there's no analogue in the diplomatic convention. Mm-hmm. But if one focuses on the four walls of what we're concerned about here, we do say it would be odd and counterintuitive for a state to have immunity, a state not to have immunity in the employment context, relating to exactly the same kind of employee, but for a diplomat to have such immunity. Now, those two cases, Single and Fonseca, whatever criticisms one can make about the length and depth of their reasoning, at least 3 points can be made in relation to them. Firstly, they evidence two other domestic courts taking a different approach to the term commercial activity to that contended for by the respondents. Secondly, there is no evidence that this has caused anything like the policy problems contended for by the respondents, despite the fact that in one case the foreign state concerned was Saudi Arabia. And thirdly, neither case was considered or cited by the principal United States court decision relied upon by my learned friends, Tabion, which I'll come to in a moment, or by the principal academic commentary relied upon by the respondents, that of Denza. So the next case, right, chronologically, in the field of diplomatic immunity still, is that of Tabion.
Right.
It's from the United States. It's at bundle A3, tab 18. MS 1672. And it's addressed in our printed case at paragraphs 52 to 53. And it's the acknowledgement that I've already referred to, that we've set out at paragraph 52, that we rely upon for present purposes. Looking solely at the words commercial and activity, the phrase commercial activity could logically encompass the respondent's dealings with Ms. Tabion. Now, the Court of Appeals in Tabion then gave initially 3 reasons at page 454 of MS 1674.
Yes.
Towards the foot of the page, 3 reasons for departing from that literal meaning, which we've addressed again in our printed case at paragraph 53. And the 3 reasons were, as the court put it, the treaty's background and negotiating history, its subsequent interpretation, and what it said would be to ignore the relevance of the remainder of the phrase outside his official functions. We then get a 4th element of the court's reasoning reflected on page 455, just above the middle of the page, after the recitation of the State Department's intervention, a reference to the doctrine applicable in United States law, but of course not applicable here, that substantial deference is due as a matter of law to the State Department's conclusion. Now, Tabion itself was, of course, not alleged to be a trafficking case. And we've set out at paragraph 53 the 4 reasons why we contend that the ultimate conclusion reached in Tabion should not be followed. The first is that the analysis of the travaux préparatoires, the reference to the treaty's background and negotiating history, overlooked, we say, important observations which contemplated the development of the meaning of commercial activity being left to case law. And it's also worth emphasizing again here that the one thing the travaux certainly did not do was address the potential significance of a diplomat's involvement in the slave trade or modern-day equivalents of that trade. The reliance on subsequent interpretation of the term, referred to at page 454, only goes so far in circumstances where that interpretation was apparently limited to the United States of America. Thirdly, United States principles of interpretation required substantial deference to be afforded to the views of the State Department, something which doesn't apply, of course, here. And fourthly, we say with respect that the court was wrong to say that a broad meaning of the term commercial activity ignored the relevance of the phrase outside his official functions. Indeed, if anything, the addition of those qualifying words would lend support to a broader interpretation of the commercial activity words rather than a narrower one. Now, Tabion is then followed by a series of other cases in the United States, which we've addressed at paragraphs 55 to 56. But the reasoning in those cases, we say, added nothing to that in Tabion. It's true that in at least one of those cases, a case mounted on the basis of trafficking was advanced. But in terms of the substantive reasoning given for resisting the claimant's argument, Tabion was held to be persuasive and followed. So, diplomatic immunity case law doesn't do anything, we say, to dislodge the provisional destination we've arrived at by reference to our first 2 stages of the argument. And the same is true if one then looks at state immunity case law. And we've addressed this at paragraphs 37 to 44 of the printed case. And the first case we rely upon there is the decision of the Canadian Supreme Court in the Canadian Labour Code case, which is at bundle A2, tab 16, MS 1600. We've sought to summarise the nature of the issue and the resolution of the case at paragraphs 37 to 39 of our printed case. And we've set out our reliance upon the reasoning of Justice LaForest at paragraph 40 of our printed case. And the Canadian State Immunity Act, like the Foreign Sovereigns Immunity Act applicable in the United States, doesn't contain a division between a commercial exception to immunity and an employment exception to immunity of the kind we've seen in the State Immunity Act here. And so the single question in these cases is, could the employment relationships at issue be said to amount to commercial activity for the purposes of those pieces of legislation? Justice LaForest's judgment begins at page 57, MS 1607.
Yeah.
You have the employees whose position had given rise to the dispute being described at page 58, at the foot of the first column on the left-hand column in English. The relevant legislation is then set out at pages 61 to 62 of the judgment. The definition of commercial activity in very general terms on page 61, any particular transaction, act or conduct that by reason of its nature is of a commercial character. And Justice LaForest then summarised the approach taken by the board, which was considering an application for certification, effectively unionisation, at pages 63 through to 68. And then Justice LaForest's own reasoning begins at page 69 under the heading Analysis. And he identifies just over halfway down the first column the two questions arising, namely whether employment at the base constituted commercial activity, and if it did, whether the specific union certification proceedings in issue were related to that activity within the meaning of the relevant act. At 71 through to 73, he describes the journey of the common law of state immunity from absolute immunity to restrictive immunity, citing cases from this jurisdiction and others. And then at page 76, he begins to answer the first of the two questions he'd posed at the outset, and the one that's important for my purposes here, namely the nature of the activity in question. And at 77, he pointed out that an employment relationship could have both commercial and sovereign aspects. And the passage is beginning one aspect of employment. At 79, again in the left-hand column, just over halfway down the page, he expresses the view that a bare contract for employment services at the base was generally a commercial activity, and that the employees concerned with the dispute would be able to sue, for example, for unpaid wages. And then at 80, for the purposes of that case, he then held that as the activity at the base had both sovereign and commercial aspects, the critical question became what the certification proceedings related to. And then finally at 88 and 89, he distinguished between proceedings seeking the enforcement of employment contracts per se and the imposition of labour relations norms, which those certification proceedings sought to pursue, and concluded that the latter, the certification proceedings, touched upon sovereign attributes because they went to the management of the base and so would breach state immunity. But in terms of the the provisional, ordinary, common sense view of whether an employment relationship not touching upon any sovereign aspects constitutes commercial activity, we say this case strongly supports our position and lends further weight to it. That's also true of the case law on state immunity from the United States of America. And we've addressed this at paragraphs 41 to 44 of our printed case, with a citation of the El Haddad decision and the Park and Shin decision. El Haddad is at A3 tab 19, MS 1677. And as I say, it's addressed at paragraph 41 of our printed case. There, the court found that an employment contract between the claimant and the Embassy of the United Arab Emirates was capable of being characterized as commercial activity, so as to fall within the exception to immunity provided by the Foreign Sovereign Immunities Act. And it remitted the case for further factual inquiry as to whether this particular employment contract did. And as the passage we've quoted, paragraph 41, coming from paragraph 18 of the judgment, illustrates, the court in El Haddad also emphasised that Congress had left the term commercial activity largely undefined, and so given the courts a deal of latitude in determining what was commercial activity. We say the same applies here. Now, to some extent, it's a footnote, but the Vienna Convention on Diplomatic Relations does itself contain, through the additional protocol, a dispute resolution mechanism relating to interpretive issues, allowing for cases to be brought to the International Court of Justice. The fact is, Saudi Arabia hasn't chosen to sign on to that protocol. But again, that illustrates that we say there was always contemplated scope for different views at the municipal level.
Yes, I note that they make, no, it's the next case where they make reference to the Tabian case, yep. Sorry, yep.
So the next case is Park and Shin,
Yep.
which is addressed at 42 to 44.
Yep.
And it's at A3 tab 20,
Yep.
MS 1683. It's again, we say, of potential importance as illustrating the oddity of the position which would apply if the respondent's submissions on Article 31 were accepted. And I acknowledge straight away that there is different wording in the Consular Relations Convention and the Diplomatic Relations Convention.
I had the wrong case, but they refer in the footnote to Tabian, don't they?
They do,
in this
yes,
case?
and they reject the idea.
They do, yeah.
And we've, I hope, acknowledged that in our printed case.
Yeah.
They
don't cast doubt on Tabian.
No, they don't cast doubt on Tabian, and there's no. I'm not submitting that as a matter of United States law, Tabian is anything other than the leading authority. It is. My point is that Tabian shouldn't be followed for the four reasons I've given, and that unless, and one of the reasons it shouldn't be followed is that there's the bright line distinction that it and other related cases seek to draw between state immunity and diplomatic immunity is an untenable one.
Yes, I see.
And it's untenable once one looks at the detail of the Vienna Convention on Diplomatic Relations and once one has regard to the fact that the interests protected under the Diplomatic Relations Convention are ultimately the interests of the state. There's a further oddity. If one is focusing solely on the question of, as a matter of policy, whether exposure to proceedings of this kind would somehow radically undermine the ability to discharge diplomatic function. There's a further oddity because Park and Shin in the United States acknowledges essentially in its result that it wouldn't do so so far as consular functions
Yes, I see.
are concerned. Now, Park and Shin is also important when one gets on to the last of our arguments, which I'll come to later, about official functions, because in Park and Shin, certainly, the court had no difficulty in concluding that engagement of a personal servant was not something which could be said to be in the exercise of consular functions. And we get that from paragraphs 8 and 17 to 18.
Thank you.
And it also held, because perhaps rather ambitiously, the respondents in that case had, well, perhaps not ambitiously, but anyway, as a matter of fact, the respondents in that case had also sought to say that they should be treated as a state, and so were entitled to state immunity, regardless of the position under the consular convention. And the court rejected that argument, saying that the hiring and payment of the plaintiff was a commercial activity for the purposes of the Foreign Sovereign Immunities Act. We get that from paragraphs 27 and 36. Now, there are 179 signatories to the Vienna Convention on Consular Relations, including, as with the Diplomatic Relations Convention, both United Kingdom and Saudi Arabia. And again, we say, as with state immunity, the position under the Vienna Convention on Consular Relations puts into proper perspective the assertions made as to the damaging consequences of Ms. Reyes' appeal succeeding. Now, I don't want to overstate the position in relation to the Consular Relations Treaty. And so, as I say, I ought expressly to acknowledge the more limited nature of the exceptions. The more limited nature of the immunity granted to consular officials, both in the criminal and the civil context, on the wording of that treaty. But I do rely upon Park and Shin and the result in that case as a powerful answer to the broader policy points that are made by my learned friends. They've cited a case concerning the arrest of an Indian diplomat in the United States, and they've cited the well-known Tehran hostages case from the International Court of Justice in support of their submissions as to the disastrous policy consequences were the courts in this country to be permitted to interpret commercial activity in the way we suggest. And we respectfully submit that is to vastly overblow the problem and to bring in very extreme contexts which have no real assistance to the present context. And the fact that they have no real assistance to the present context, we say, is well illustrated by that case law which we are able to point to in this specific field of employment relationships, whether it's the diplomatic immunity cases, whether it's the state immunity cases. Now, the approach of the Court of Appeal to our arguments based upon state and consular immunity was to say that they had limited relevance to the interpretation of a treaty on diplomatic immunity. This is paragraph 26 of the Court of Appeal's judgment. And that they were not decisions on the 1961 Convention, paragraph 28. And that is, in essence, one of the key lines that the respondents take on this appeal. Now, it's of course true that those cases were not decisions on the 1961 Convention. But it is respectfully submitted that the Court of Appeal was wrong to treat them as being essentially of no material relevance. And we say that the Court of Appeal's approach overlooked at least three matters of importance in that regard.
Which paragraph is it? Paragraph 29, is it?
It's paragraphs 26 and 28 where the Court of Appeal deal with this, my lord, I think I've my note correct. You have my citation of United States case law and the Court of Appeal's response at paragraph 26. And then you have, so far as state immunity is concerned, where I deal with the Canadian Labour Code case in particular. And then at paragraph 28, you have my submissions on Park and Shin, the consular case we've just looked at. And the Court of Appeal, in the last sentence of paragraph 28, I would decline to follow it for the same reasons as I have given for not following the Canadian decision in the Canadian Labour Code case. So we say the Court of Appeal's approach and that of the respondents overlooks three matters of importance. The first is that the second and fourth recitals to the Vienna Convention on Diplomatic Relations made it clear that the core principle underpinning state immunity, that of state equality, was of relevance to the 1961 Convention. If we can go to the Vienna Convention itself, at tab 2, MS 988, you have the two recitals that we rely upon are the one beginning, having in mind the purposes and principles of the Charter of the United Nations concerning the sovereign equality of states, maintenance of international peace and security, and the promotion of friendly relations among nations. And then the next but one, realizing that the purpose of such privileges and immunities is not to benefit individuals, but to ensure the efficient performance of the functions of diplomatic missions. Now, those are exactly the same recitals, I think word for word, to those used in the Consular Relations Convention. It's acknowledged that by the respondents themselves, paragraph 70 brackets 1 of their printed case, that the core principle underpinning state of immunity is that of state equality, the concept that we see reflected in the second recital there. And we say both of those matters suggest at least a relationship between diplomatic immunity and state immunity. And that suggestion of there being at least a relationship is then reflected again by the point that's already arisen in the question posed by my Lord Sumption, which one gets from Article 32(1) of the Convention, that the immunity from jurisdiction of diplomatic agents may be waived by the sending state only. Now, in urging this court to conclude that the law of state immunity provides no assistance at all, the respondents, as they did before the Court of Appeal, refer repeatedly to the fourth recital, the functional purpose recital, but make no reference whatever to the second one. In fact, as we submit, properly analysed, the fourth recital also supports relevance of state immunity. The second point which we say the Court of Appeal and the respondents overlooked, consistent with that argument, is that the decision of Mr. Justice Laws in Prop N, which we'll come to in a moment, and which was, of course, itself substantially relied upon by the Court of Appeal, had expressly characterised the law relating to diplomatic immunity as not freestanding from the law of state immunity, but rather as an aspect of it. And that's the point we make in our printed case at paragraph 60. And the third point is one we make slightly later in our printed case at 65, and it's a broader one, and it's this, that at the time the 1961 Convention came to be negotiated, the transition to the restrictive doctrine of state immunity, precluding immunity for commercial activity by states, was already well underway. And it would be odd, it is submitted, to proceed on the basis that the same term should have substantially different meanings in the state and diplomatic immunity contexts, or if the reach of immunity should be so markedly different on functional grounds as between consular officials and diplomatic officials. And we've cited, just really as it's a convenient place where it's drawn together, in paragraph 65 of our printed case, the history of the evolution from absolute to restrictive immunity set out in Trentex. The result would be that there would be what some academics have described as dissonance and confusion, or fragmentation, in what we say must at least be characterised as related areas of law. And the principal academic writing we've cited on that, I don't need to turn to it now, but it's from Professor Mullally at Bundle A, tab 12, Bundle A12, tab 131 at MS 4670. Now, in their printed case, the respondents also repeatedly assert that it is simply misconceived, as they put it, to draw upon state immunity authorities in the context of diplomatic immunity. And they cite two authorities for that proposition, the Aldona case and the Empire of Iran cases. And the references, I think I picked them up comprehensively in their printed case, are paragraphs 17, 62, 2, and 70. And they contend that the assertion of civil jurisdiction would inevitably interfere with diplomatic function. Now, we say that properly analysed, neither the Aldona case nor the Empire of Iran case materially advance the respondent's position at all. The Aldona case was originally in the bundle, but not in a terribly well copied version, I'm afraid, and so a terribly legible version. It's more conveniently found, I think, in the respondent's supplementary authorities, the authorities bundle that came in last week.
Yep.
My version, I'm afraid I don't have the tabs, but
Right,
it's page 3.
Thank you. Yes, tab 174, I think. Is that right? Thank you. Yep.
Now, this was a state immunity case, which predated the Vienna Convention on Diplomatic Relations. So there's a limit to it, we respectfully submit already. And while it is true that, and it was a case which, of course, was decided at a time when, at least in this jurisdiction, absolute immunity still held sway as a matter of state immunity. principles. Now, it's true that it held that the legal basis for the immunities was different, and it held that domestic law provisions relating to diplomatic immunity could not determine the correct approach to state immunity. So, in a sense, it was the obverse of the argument that's before the court, and we get that from pages 224 to 225.
Thank you.
But it also held, and we get this from just above, halfway down on page 225, it also held that the principle of sovereign equality informed the approach to both diplomatic and state immunity. In the bracketed words, the principle must also be taken into account with respect to diplomatic immunity, notwithstanding the different aspect of the latter.
Yes.
The Empire of Iran case is at bundle A11, tab 115. And MS page 4515. It was also a state immunity case, and it said no more, we say, than that diplomatic immunity could extend beyond state immunity. It also held, perhaps importantly, given the way the respondents put their case, we get this from page 80, MS 4538, towards the foot of the page, and indeed from the headnote, I think, that there was nothing objectionable in principle with municipal courts being charged with responsibility for characterization of acts as sovereign or non-sovereign. So here we say there's nothing objectionable in principle in the exercise that we are asking the court to engage in.
Which was the passage that you had in mind when you said that it is authority for the proposition that state and diplomatic immunity are not necessarily coterminous?
Misplaced my...
You let me have it in due course.
Thank you, my lord, I will. And our answer to that is, as I acknowledged in my answer to my lord earlier, there may be circumstances in which a diplomat may have greater immunity than a state. And one example, based on our own legislation, was the one about damage to property in jurisdiction. But my case is where you've got exactly the same term being used in both contexts, then it's particularly jarring to adopt a completely different meaning in one as opposed to the other. It's also right to note, we say, that at least some of the academic commentators acknowledge a link between state and diplomatic immunity. Sato goes as far as to say that to a large extent state and diplomatic law are now in conformity in respect of the extent to which a foreign state's immunity today restricts the jurisdiction of the receiving state. I'll just give the reference to that, if I may. It's bundle A3, tab 33, MS 1847, and the paragraphs are 1254 through to 1264. So...
Sorry, can I have those references?
Yes, my lord. MS 1847, bundle A3, tab 33, and paragraphs 1254 to 1264.
Yep.
So that's Aldona and Empire of Iran. They go nowhere near far enough for the respondents' purposes, we say. And as to their assertion that any interpretation of commercial activity of the kind we contend for would inevitably represent an unacceptable, uncontemplated level of interference with the diplomatic function, so as to build their case by reference to the diplomatic function in the fourth recital, we say that goes far too far, for the reasons I've already sought to explain. We know from the wording of Article 31(1) that it was not considered completely off limits for there to be any exercise of civil jurisdiction over diplomats. If the logic of interference with diplomatic function were as stark as my learned friend suggested to be, there would have been an absolute immunity from civil jurisdiction, just as there is from criminal jurisdiction. And again, as I say, if one's focusing solely on this functional question, and an argument is sought to be built around an assertion that individuals, as opposed to states, will face particular vulnerabilities and so need particularly high levels of protection, we say, well, if that's so, why isn't it so in the consular context? So that is what we say so far as stage one, if you like, of the Vienna Convention on the Law of Treaties exercise is concerned. Ordinary meaning of the words commercial activity. And again, they point strongly, we say, to the conclusion that an employment relationship, at least of the kind with which these proceedings are concerned, falls within it. All the authorities show that the literal meaning is wide enough. The decisions from Canada and Portugal are entirely consistent with the approach we contend for. The decisions from the state immunity context are entirely consistent with the approach we contend for. And the United States line of cases, beginning with Tabion, should not be followed for the four reasons we've set out at paragraph 55 of our printed case. And that conclusion is not, we say, altered once regard is then had to their context and purpose, and to the context and purpose of the treaty, whether one draws solely from the wording of the treaty and its preambles, or whether one engages in the exercise of looking at the travaux. So far as context is concerned, we've addressed this at paragraphs 69 to 73 of our printed case. And on this, the Court of Appeal had regard to four particular provisions of the Vienna Convention or its preamble in concluding that we were wrong. And the four provisions that the Court of Appeal had particular regard to, if one goes back to the Vienna Convention at Bundle 1, Tab 2, page 988, MS 988, the four provisions the Court of Appeal had particular regard to were the fourth recital, the one beginning realising that the purpose of such privileges.
Yep.
Article 3.1,
Yes.
functions. Article 34, dealing with exemptions from dues and taxes. And of course, Article 42, the article that gets most consideration in prop end and so forth. Now, the recitals and Article 3.1 first. So far as they're concerned, we make 4 points. Firstly, as I've just pointed out, the second recital, not referred to in this context by the Court of Appeal or by the respondents, suggests a close relationship between state and diplomatic immunity, consistent with our arguments. Secondly, the fourth recital, with its reference to the efficient performance of the functions of diplomatic missions, does not, we say, indicate that the term commercial activity should not ordinarily embrace employment contracts. Instead, if one's trying to look for what words in Article 31(1)(c) might be read as responding to that recital, we would say it's the inclusion of the words outside his official functions. The fourth recital doesn't tell us anything about the meaning of commercial activity, we would respectfully submit. The third point is that the functional nature of immunity, we say, only goes so far. Again, as I've already submitted, it's implicit in Article 31(1)(c) that not all assertions of civil jurisdiction will impair the discharge of a diplomatic function. And there's certainly no reason why an assertion of such jurisdiction in relation to employment claims relating to trafficking would do so. And fourthly, Article 3.1, and I accept immediately Article 3.1's list of functions isn't the beginning and the end of the story for the purposes of official functions and what it means. But it certainly doesn't suggest on its wording that employment of an individual for the provision of purely personal services is part of the diplomatic function being referred to in the fourth recital, let alone where that employment amounts to involvement in trafficking. And that then leaves, so far as the Court of Appeal's context drawn from the treaty and the preamble are concerned, only Article 34D, the provision relating to exemption from dues and taxes and so forth. Now, that article makes it clear there will be no exemption from taxes on private income having a source in the receiving state. But that doesn't tell us anything, we respectfully submit, about the meaning of the term commercial activity. It, of course, underscores the fact that the exception to immunity extends to tax liabilities for private commercial activity, yielding a specific income. But we say the exception is manifestly not limited to that. My Lord, my Lady, that's 1 o'clock. I was going to deal with Article 42 next, and I'll do that at 2, if I may.
Very well. We'll adjourn now and resume again at 2 o'clock. Thank you very much. Court's now adjourned.